Okay, good afternoon, everyone. My name is Jeremy Herman. I am an employment lawyer at Samfiru Tumarkin, LLP. I'm located in Toronto. We have offices in Ontario, one in Toronto, one in Ottawa, and we also have offices in Vancouver and Calgary. As you know, we do many of these live sessions every week, and the whole purpose of these live sessions is to have your employment law questions answered. So now's the time for you to ask your questions, post them in the chat, get them answered live. This is a free and very valuable opportunity to learn more about all the important and pressing topics in employment law. And I'm here for a half an hour to answer your questions. So I'm looking forward to it. As I always do, I will start off the session with an important topic, and then we'll dive into questions. And so what we'll start off with talking about is just the many tech layoffs that are happening. We've seen it in the past several months. There's been layoffs in the tech industry. It's rampant. We've seen layoffs in Amazon and Microsoft and Meta, Dell, and many other tech companies. And another tech company, a smaller one called Hopper Inc., which is a Montreal-based company, has just cut 30% of its full-time staff. In other words, 250 jobs. And it's always because they're suffering financially, the organization. And so if you're facing one of these layoffs, or if you know someone facing one of these layoffs, they should absolutely contact our firm. You have rights if you're laid off, and your rights are significant. Your severance pay could be as much as 24 months of pay. And throughout the session, we're going to talk about how severance is calculated, but it could be very significant. So definitely don't hold off, and contact us if you are terminated or laid off, or like I said, if you know someone facing these layoffs. Okay, so with that intro, we will get into the first question on YouTube from Robin. So Robin says, I'm currently on WorkSafe. They told me to return to work and see if my employer can accommodate me. Does the employer have to accommodate me? Or if they can't, then what happens? Okay. Great question. So yes, your employer has to accommodate you. Your employer generally in Ontario and across the country, they have a duty to accommodate you. And there's a standard, and the standard is up to the point of undue hardship. That is the legal standard. And that's a very high threshold. So assume that if you have some sort of accommodation that your doctor has recommended, for example, your employer absolutely has to accommodate that, so long as it doesn't cause undue hardship for the employer, which is, again, a high threshold. So, for example, you could have been on a medical leave, and you come back to work, and your doctor prescribes a plan. And part of that plan is that you take 30-minute breaks instead of 15-minute breaks. And if the doctor has actually recommended that, so long as that does not cause your employer undue hardship, your employer absolutely has a duty to accommodate that. So that's just one example. It could be the length of your breaks. It could be how many days a week you work. It could be certain chairs or desks or keyboards that you might need. Obviously, it depends on what the issue is. It could be having to leave early to be able to deal with your ailing child or parent. There's a variety of issues that an employee could experience, but generally, yes, your employer has to accommodate you. And if they don't accommodate you, getting to the second part of your question, Robin, then that would be a breach of our Human Rights Code. So the Ontario Human Rights Code says that the employer has to accommodate you up to the point of undue hardship. And so if they don't do that, that's a breach of the Human Rights Code, and you can certainly treat that as a termination and pursue your full severance. And in addition, you might be entitled to human rights damages as well for the breach of the Human Rights Code. Okay, Robin, I hope that answers your question. And if you have another question, then please post it in the chat. Let's move on. So Scott on Facebook says, how can a company offer only to pay their terminated employees by virtue of assigning a waiver and giving up all your rights to further legal action? So Scott, it sounds like what you're talking about is a release of liability. And it's very, very common for an employer who terminates an employee to say, we're offering you this severance package. Let's call it 5 months of pay, for example. And in exchange for that 5 months of pay, you have to sign a full and final release. Now, that is exactly what you say it is, Scott. It releases the company of any and all future liability. And so you have to be extremely careful before you sign that full and final release, because you might be entitled to 20 months of pay, but your employer has only offered you 5. And if you don't do anything about that, you don't contact our firm so that we could properly advise you and negotiate a proper severance package for you, and you go ahead and you sign that full and final release, you have very little recourse at that point, if anything at all. And so don't sign any termination documents when they're presented to you. You got to contact us and we will advise you whether the offer that's being presented is a good offer or not. And you certainly don't want to sign a full and final release if there's no offer that's being presented, which sometimes could occur. That an employer will present you with a full and final release, and there's not really anything in exchange for that is of value to the employee. So that would be certainly problematic from a legal perspective. So yes, it's very common to present full and final release documents to employees. Make sure that you don't sign it, though, until you've spoken with us. Very, very important. You don't want to leave money on the table. And most of the time, an employer who terminates an employee is not going to offer the employee their full entitlement to severance. They're going to offer something less, and often it's a lot less than what the employee is entitled to. Okay, Scott, I hope that answers your question. And if you have a follow-up, please post it in the chat. Now, as you see on the screen, there's a note about the Pocket Employment Lawyer tool. And let me just speak a little bit about that. So the Pocket Employment Lawyer is a tool that we have. You can visit the tool at pocketemploymentlawyer.ca. Part of that Pocket Employment Lawyer is what's called a severance pay calculator. And as you see on the screen, you can find out how much severance you're owed by using our free and anonymous severance pay calculator. And it will ask you questions that are relevant to assessing how much severance you are owed. Questions such as what is your age? What is your occupation? How much money are you earning? How long have you worked in that occupation for a given employer? So all of these things are relevant in determining how much severance you're owed. Like I said, it is a completely free and anonymous tool. If you've been terminated, you certainly want to check it out to get a sense of what severance you're entitled to. And even if you haven't been terminated and you don't even foresee being terminated, but you're kind of just curious to see what are my severance entitlements, check out our Pocket Employment Lawyer tool. Look at the severance pay calculator, use it, tell your friends about it, and it's a great tool to determine what your rights are from a severance perspective. Okay, so before I move on to further questions, I want to talk about another important issue. And what that is what is your right as an employee if you work for a company and the company is bought out by another company? So in other words, this is what's called an acquisition. So you work for company A and company A is bought by company B. What are your rights? How are you impacted? So let's go through some of that. So if company A that you work for is bought by company B and you don't have a job at company B, so company B is buying company A, but you're not going to be able to continue in your employment with company B. You're not going to have the same job that you were doing for company A. So in that case, you're owed severance because you're being terminated because you don't have a job anymore. And the question is, who owes you severance? Is it company A that you worked for, or is it company B, the new company that bought company A? And so the answer is that, generally speaking, company A owes you the severance. And that is the company that has legal obligations towards you. Now, you'd be entitled to your full severance pay, which could be as much as 24 months of pay, depending on your particular circumstances in that case. Now, what happens if company B does offer you another job that's very similar to the job you did at company A, if not the same job? So in that case, we would say that it's expected that you take the job with company B. Of course, you're not forced to do anything. You don't have to take the job with company B, but your severance entitlements would not be the same. So if you have a job that you could take, it's the same job as essentially that you've done for company A, but you choose not to take it with company B, you're entitled to your minimum severance entitlements, but not your full severance entitlements in most cases. Now, if you have a good reason not to take the job with company B, because maybe they're offering you a job, but they're making you sign a new employment agreement, or they are saying that you have to work at a different job location, or they're changing the rate of your pay or your work hours. For any of those reasons, that would be a significant change to the terms of employment that you're used to. And so you wouldn't have to take the job with company B if that was part of the offer. And you would have a good reason to not take the job with company B, and you can pursue your full severance from company A. So just to put this into perspective, so the company Suncor Energy has announced a major acquisition. They're buying the company Total Energies. And so all the employees of Total Energies, if they are not offered jobs with Suncor, then the Total Energies owes their employees severance. If the employees are offered jobs with Suncor, and they're very similar jobs, in most cases, they should take the job with Suncor. If they are offered a new job with Suncor, but it's drastically different from the job they worked in at Total Energies, they don't have to take that job with Suncor. So just to put it into perspective, because that's a real live example of what's happening right now. So it's an involved topic. If you're facing one of these situations, certainly let us know, and we will advise you on what your rights are and how to best pursue this legal problem in your case. Okay, so let's dive back into questions. We have a question from Evan on YouTube. I'm being forced to move into a different position at my job and not being paid for the training. I do not want this new position. What can I do? So good question. Evan, that could be a situation of a constructive dismissal. That's what it sounds like to me. So let's explore what that is. So a constructive dismissal, we've talked about it many times in our live sessions, and it's important to talk about it. So a constructive dismissal is a situation where your employer is not terminating you outright, but they might be changing drastically certain terms of your employment. Could be that they're changing your position. It could be that they're keeping you in the same position, but they're changing your rate of pay or your work hours or job location. All of those things would be a constructive dismissal, and you'd be able to pursue your full severance entitlements. You would be resigning from your employment, but not voluntarily. It's a resignation as a result of the significant changes that your employer has implemented, and therefore you have your severance entitlements. We see constructive dismissal cases all the time. They're very common, unfortunately. And so if your employer is implementing changes to your job, don't just assume that they can do that. Okay? You have to contact us and we'll let you know whether it's legal. Now, there are situations where your employer can implement certain changes to your employment. So there could be a case where you have an employment agreement that very clearly and legally says that the employer can implement changes to your employment. So in that case, you may not have a constructive dismissal claim anymore because you've agreed to it in your employment agreement, that your employer can implement those changes. So every case is different, but generally speaking, the law is that your employer cannot do that. If you are facing one of these situations, contact us and we will review your case with you. Every case is different. Let's see if you have an employment agreement. Let's see if the employer is permitted to do this. Usually they are not, and you can pursue your full severance entitlement. Okay, so Evan, I hope that answers your question, and let's move on. We have a lot of questions to get to, which I'm pleased about. So we have a question from MP on YouTube. What does a probationary release entail from an employer perspective in Ontario? Okay, so if you are an employer, sounds as though you might be an employer, and you want your employee to sign a release, it's going to contain, each release could be different, but it's going to contain covenants such as that the employee has to keep whatever settlement very confidential. It might say that the employee cannot speak negatively about the company. In other words, non-disparagement clauses. It might say that the employee is responsible for any taxes or any employment insurance benefits that they might have to repay as a result of receiving severance. Those are some of the key terms that a release would entail. And of course, the main term is that the employee is releasing the employer of any and all liability. So in a nutshell, those are the terms that a release has. But again, every release is different. It really depends on the situation. So I hope that answers that question sufficiently. And if you have a more specific follow-up, feel free to put it in the chat. Okay, so Scott says, these people still haven't even received their vacation and severance pay after 2 years. Okay, so Scott, I'm not exactly sure what you're referring to. What I can say is that with respect to 2 years, a person has 2 years after being terminated to pursue their severance entitlements. So that's one important piece. So if you're terminated on October 5th of 2023, you have until October 5th of 2025 in most cases to pursue whatever entitlements you have. That is the general limitation period that we work with in Ontario. Okay, next question on YouTube. Can an employer take action against you for your activity on social media if you comment on or support political parties' posts? Generally speaking, no. I mean, you're free to like and share or whatever you want on social media, so long as it doesn't actually conflict with your employment in some way. So no, your employer shouldn't be able to take action against you for that. But again, this is very fact specific. So what I do encourage you to do is, if you're facing that kind of situation, arrange a consultation with us so we can learn more about your specific occupation, what kind of employer you work for, what kind of social media activity are you referring to. If you suffered any sort of reprisal as a result of that from your employer, what did that look like? It's very fact specific. So let us know, and we'd be happy to speak with you about that. And as you've seen throughout the session, you can learn more about all of these topics at employmentlawyer.ca. We have a wealth of information on that website about all of these key employment law topics that people deal with on a day-to-day basis. So make sure that you check that out. Another important tool is that you contact us. You can do that at help@employmentlawyer.ca. Okay, question from Sandy. How can I word a separation letter to employer that implies it is a constructive dismissal due to contract breaches on their part? I want to leave the legal option open for later. And then you follow up, Sandy, you say 4 to 5 coworkers have all been terminated since May, want to file a class action dismissal suit. How do we proceed? Or unjust dismissal. Okay, so there's a lot packed into here, Sandy. You should at least yourself arrange a consultation, but if all of your coworkers need to do so, they absolutely should. Each case is different. And so I encourage that each of you arrange a consultation with us. You can contact me directly. You can contact us at helpandemploymentlawyer.ca and we'll help you out. What you should note is that if you're pursuing a claim under the unjust dismissal sections of the Canada Labour Code for a federally regulated employer, you only have 90 days to do so. So that's a very, very important piece of information. After 90 days, you can't proceed under that section of the Canada Labour Code for an unjust dismissal complaint. And typically in these kinds of cases, it's probably better off that we deal with each of these individually, not as a class action. But again, contact us and we'll review with you and we'll determine what the next step is. Okay. We have a question from Scott. Again, that's what they wanted the waiver for. So they wanted a waiver. They were offering vacation and severance, and then they wanted a waiver for it. So, I mean, one important thing to note, Scott, is that you can't sign a waiver, or you shouldn't be signing a waiver or a release of liability of your employer if you're only receiving your minimum entitlements under the Employment Standards Act. You don't have to sign anything in order to get those minimum entitlements. So your minimum entitlements to notice or pay in lieu of notice, your minimum entitlement, if it's applicable to you, to statutory severance pay, vacation pay, any outstanding vacation pay, all of these things are your minimum entitlements. Or if you're enrolled in a benefits plan, there's a certain minimum amount of time you have to be enrolled in that benefits plan after termination. If that's all that's being offered to you, you don't have to sign any release of liability. You only release an employer of liability if they're offering you something in addition to what are your minimum entitlements under the Employment Standards Act. And you wouldn't sign it right away, like I emphasized at the beginning of this session. You first contact us. Let us review what is actually being offered to you, because there could be much more to negotiate there. Okay. Let's move on. So we have a question from Michelle on Facebook. Can my employer make me work from home permanently? Interesting question. Typically what we see is people complaining about having to go back to work when they were working from home, such as during the pandemic. And what we've said in those cases is that if you were only working from home as a result of the COVID-19 pandemic and prior to the pandemic, you have worked in the office, then generally your employer can make you come back to work and work from the office. Now, if you've always worked from home, even prior to COVID, and now after COVID, you are being asked to come and work in the office, then that would be potentially constructive dismissal, because it is a change, a substantial change to a fundamental term of your employment, which is your job location. So in this case, Michelle, I would say something very similar. It's the opposite, but you can potentially treat it as a constructive dismissal, but I'd have to know more. It really depends on, is it because your employer doesn't have a job site anymore? Are they getting rid of their office space? These things, it depends on those factors as well. So I encourage you to contact our firm, and we can learn more about your case, and we'll advise you further on that. It could be that you have a constructive dismissal case. Okay, let's move on. So we have something from Dole Drew on YouTube. Ontario hospitals are still using Directive 6 to prevent suspended unvaccinated employees from returning to work, and that union seems useless in countering. How is this legal 2 years now? Okay, so first thing I'll say is that if you're unionized, unfortunately, we can't help you. You have to go through the regular grievance procedures with your union. Difficulty if they're not helping you with that. let's move on to another question. Okay. So we have a question from Ash B on YouTube. Is a verbal notice by an employer for closing the business considered a notice? Employer is looking to retire and said he will likely wind up in 6 months' time. Good question. So an employer has to provide you with notice of termination. It's a general law. Okay, under the Employment Standards Act in Ontario, they have to provide you with a certain amount of notice, and that will depend on how long you've worked for the company. And what they can do is provide you with notice as opposed to pay in lieu of notice. What's very common is that an employer will say, you're being let go effective immediately, and instead of providing you with the 6 weeks of notice that you're entitled to, we're going to give you 6 weeks of pay in lieu of notice. But your employer can actually provide you with what's called working notice, which means they're letting you know 6 weeks in advance. And I'm just picking that as an example. You might be entitled to 4 weeks or 8 weeks or 2 weeks. But let's just take an example of 6. So your employer might say that we're letting you know that in 6 weeks from now, we're closing up and you're being let go. So if that's the case, that could be effective notice, but it really depends on how they told you about it. So if they're just verbally letting you know, it's likely that that is not effective notice. They have to actually put it in writing. We typically say that working notice has to come and it has to clearly set out a date that you will not be working for the company anymore. It has to state it in writing. So Ash, if you receive verbal notice from the employer that they are retiring and winding up shop, then that may not be sufficient. They have to actually provide you with it in writing. So contact us and let's see what we can do about this. It might also be that 6 months is very insufficient. It could be that you're entitled to, according to the common law, you could be entitled to 20 months or 24 months. It depends on your factors, right? Your age, your length of service, what position you're in, how much money you're earning at that employer, the availability of similar employment opportunities in the job market. These are all the key factors that are used to determine your severance or your notice. And so contact us and we'll let you know whether the notice was effective and whether you're entitled to much more than what's offered, which, as it seems, is 6 months of pay. Okay, so we have, looks like we have a follow-up from Michelle. So I can answer that and then we'll move on. So Michelle says they've closed their office space and that's why they're making you work from home, but I do have a private area to work from home. Yeah, so I mean, it's not the best case. I'll be honest with you, Michelle. But again, I have very limited facts right now. So if you can work from home and you have no particular reason why you're not able to, it's just not your preference, you may not have a constructive dismissal claim there. But again, I urge you, contact us. Let us review everything with you. Let us get on a phone call and actually discuss this with you. We'll need to review your documentation as well. We have to see what the employer is actually put in writing, and then we can provide more fulsome advice on your particular situation. Okay, I hope today was helpful. I'm going to be back with you soon. Join us live again tomorrow at 10:30 a.m. with my colleague Teelan, and we'll see you soon. Have a good Thanksgiving weekend. Take care.